Welcome to the continuation of Session 6, in which we look at intellectual property and make some considerations of strategy, value, and litigation. Lecture 2 of this two-part series, again, we're going to focus on valuation of intellectual property, some overall strategies, and talk a little bit about some litigation issues. As before, the textbook is very helpful in clarifying certain points that we won't discuss here. As we mentioned in the first lecture, intellectual property is a strategic asset, and essentially it must be managed. It must be managed strategically. So this requires sort of an idea of what your underpinning strategy is, how you're going to create revenue, how you build markets, managing competition, all those kinds of things. And I think what we have to realize is that the intellectual property attorney is an important member of the team, is as important as the accountant or the research scientist. And the book talks a little bit about this this strategic pyramid, which I would encourage you to dig into when you have a chance. I think what sort of strikes people odd is that if you do something important, litigation is inevitable. I don't think it's possible to move in a competitive environment without at some point being presented with litigation. Again, as we talked about, we'll speak a lot in this particular lecture about intellectual property being synonymous. We're speaking synonymously about patents, but again, as we talked about last time, trade secrets can offer protection too. I think what we want to do is understand that strategies can be defensive, where you have you want to deliberately keep people out of your space, and in this domain, continuation claims are the key, and that is to say, new claims on old patents. That seems to be controversial these days, but basically, still, the game of continuation claims can take a patent that's ready to expire and provide additional protection years and years into the future. So this is defensive strategies, again, keeping people away from you and continuing claims. But they can be offensive as well, and that is to say, what you need to do is strategically anticipate what your competitors will do and attempt to block them. So you might not be interested in particularly patenting something in a particular area, but if you understand your competitors heading in that direction and you have some good ideas, why not patent? And then, of course, this could be the basis for licensing deals. I think another thing that needs to happen is that for any given entity, you have to understand your business risk threshold. That is to say, what are you willing to pay to defend your IP? This is something that's going to be very visible as you get into anything that's important in which litigation is inevitable. You have to have what we call liability reserves. And in fact, when people look at balance sheets, when they try to anticipate how strategic you are, they might want to look at your estimated liability reserves. The more reserves you have, the more risk taker you are, and maybe the more competitive you are in the market. So what is it worth to protect IP? You have to go through this valuation process. And I found that there's basically 10 common techniques out there. I have a publication on this that I'll refer you to, so I'm simply going to highlight some of the features of this in the next slide. I think everybody has a favorite. There's the idea that the seller versus the prospective varies widely, just like real estate. Sellers and buyers have different views on what their property's worth. Same thing with intellectual property. So eventually what you have to do is to get a third party involved to really sort of negotiate exactly what the valuation of your intellectual property is. Normally what I've done is I've down selected from the 10 common techniques to basically 3 or 4 for a pro forma. And of course it doesn't take much, but you really want to explain why you pick the techniques. Out of 10, any 3 will be fine. Average them, and you'll be pretty much close on the mark in terms of what the market will value that intellectual property as. And I guess you have to really begin to answer the questions. If you do a strategic analysis and you do a revenue analysis and you anticipate that over a 5-year period, let's just say your product's going to bring in $4.5 million, you have to begin to understand what are you going to be willing to spend to protect that revenue. Okay, so again, I want to emphasize that evaluation and intellectual property go together. It's all about strategic management of IP, not just creating IP and having it sit out there and just wait for something to happen. Okay, the 10 methods, at least the 10 methods that I've typically used, really fall into 4 categories. That is to say, portfolio compatibility with the venture capitalist. So you're going to take the VC approach or the 3-minute test. That is to say, people ask, there's a list of 20 questions, and if you fail 3, you're out. So then the VC approach is what they're willing to pay and what their comparables are. Again, this is very highly qualitative. So this might be some things that are done up front, even before you look at, say, investments from a venture capitalist. So I don't really consider these because these are things that I really couldn't control, whether I'm at a company or a startup or anything like that. I have liked one of the income approaches in which I anticipate the value of the assets is providing cash in the future, and what I want to do is I want to discount that cash flow to the present, and that gives me a valuation. I also like to diversify and have a market approach and look at a similar company revenue multiple and see what the valuation of IP is for a similar company, and maybe we just revenue, do a multiple of the revenue as a way of enhancing the value. And of course, the asset focus, what would it take to replace the intellectual property, the investment in the intellectual property. So this is kind of a straightforward one. The one that's really most popular and people tend to focus on, I think because it's got a lot of numbers, is the discounted cash flow technique. And really what that discounted cash flow technique represents is, again, you've created intellectual property, and this intellectual property is believed to provide income in the years ahead. So let's just say that we presume that the peak of the life of this patent is 5 years. It could be much longer. And what you want to do is estimate what that net income is in the years ahead and then discount it to the present so you get a net present value. So for instance, if I look at the net income as a result of investing in IP and launching the product, this could be sort of the product development phase, and then I'm out to years 5, maybe year 6, maybe year 7, but I anticipate these to be the revenue associated with this patent portfolio. Then what you do is discount it to the present, and so you could do a couple things. You could do a lower bound where the net present value over a 5-year period with a 10% discount, which is pretty modest, you get a company of about $3.1 million. Upper bound would be to expand it out a few years with a particularly aggressive growth assumption with a discounting rate of, say, 17%, which is a little bit more aggressive, and you end up with an $8 million company. And basically what you do is you average them, and you end up with a $5 million company, or $5 million post-IP valuation. So this idea of intellectual property valuation, unfortunately, people will stick to the discounted cash flow and be very firm about, well, we're only going to look at 5 years, and we're going to do this, and we're going to do that, for the assurance that they can get a very specific number. The reality is, let's go back one slide, we have all these different methods, and I assure you that the values will vary widely. So what you want to do is to get a lower bound, an upper bound, an average, and that's probably going to be pretty good as a starting point for discussions. Okay. Strategic management of IP, as I've alluded to earlier, competition eventually means infringement. So let's suppose you've had some ideas, you have a business strategy, you've decided that for that business strategy you need to invest in some intellectual property, whether it's a patent, trademark, whatever it is, and so then you're out in the market. Once you get out there, if you're successful, competition will somebody will accuse you of infringement. They'll claim you're not that original. So lawsuits typically arise when discussions for a license fail. Somebody says, hey, you're using my patent. And you're like, no, I don't think so. And so they're pushing for a license, and you're like, nope. I'm not going to license that. So when discussions fail, or when the patent holder wants exclusivity, so that is to say somebody's not interested in licensing and seeing the innovation spread into the marketplace among multiple people, they don't want anybody. This is a defensive strategy. They want to block everybody out. So, when you're threatened with infringement, you basically need to contact your staff lawyer, your consult, and obtain a legal opinion on whether the patent really is infringed. Sometimes people will claim infringement just to see what you do, or the patent is so weak it's unenforceable. Okay? So you can file a declaratory judgment suit that the patent is valid or not infringed. So somebody shows up, they say, I think you've infringed, and you can respond and say, no, I don't think so. It's actually quite simple like that. Get a lawyer, of course, to help you with the documentation. So why is litigation so expensive? Let's dig into that for just a moment. First, let's look at some definitions. When we talk about a patent prosecution, what we're doing is we're working with an attorney to protect the inventions of the company by creating intellectual property. Okay? And again, this is a preventative measure. Patent litigation, on the other hand, is when the when the attorney works with the patent to stop others from using your patent. So when we speak of, we also think of prosecution as a legal, which it is a legal term, but in our case we're really focusing on something called patent litigation. I just wanted to briefly mention the difference in those definitions. Well, before you sue, or before, in terms of thinking about whether you get sued, you really have to decide, does the situation reasonably suggest that infringement occurs? And if so, the plaintiff sends a letter, and they may say, request a royalty, I think you're infringing, and I want a cut of the action, or you're going to say, I want you to cease and desist, and this would be a stop and refrain from letter by a lawyer. So maybe you send that letter out. If you have no satisfaction, then you have a foundation to formally file a complaint. And federal rules generally require a patent holder to have a reasonable belief that the patent is infringed before a suit is brought, and that is to avoid frivolous lawsuits, people just arbitrarily suing to keep people locked up in court. Once you formally file the complaint, you've got 20 days to respond, and then we're what we call off to the races. So let's take a look at what the overall process looks like in a minute, but I want to mention first several defense mechanisms. One is, if you're sued, you can say, hey, there is no infringement. Or you can say, the patent is invalid. In your opinion, the patent is obvious to one skilled in the arts. There's statutory. This thing was on sale a year before the patent was filed. Or enablement. You can say, gee, you've got a patent, but it doesn't describe the patent well enough. And definite, the terms for the claims are not definite, so it's not very specific. Or you could claim that the patent is unenforceable. You could be claiming that the plaintiff that the patent office was materially misled during the patent prosecution, again the development of the patent, by the plaintiff, and therefore it's invalid because the plaintiff misrepresented what was being presented. There's this thing about latches in which there's a delay in bringing a lawsuit, in which you waited too long to bring a lawsuit, and there's other legal terms as well. So basically, again, we have we have four major categories for defense mechanisms. First of all, there is no infringement. 2, the patent is invalid. 3, the patent is unenforceable, or there's a fourth category. This is sort of grasping, and what it is when all else fails, claim antitrust, unfair competition, or re-examination. We can talk offline or have a separate session about this latter ones. It's actually some very strategic activities. That is to say that if the patent, paradoxically enough, let's just take this one as an example. Let's just say that the patent, of course, gives somebody a limited monopoly. But you might argue that the monopoly is too strong, and therefore the person is in violation of antitrust laws. So you'll see that a lot in court cases when somebody fails to get a positive verdict. So again, now let's take a look at the basic process. Basically, there's a pre-litigation investigation. Something's happened. You believe there's been an offense. So, you do some discovery, and then, of course, you file a complaint. And then you have 20 days to answer that complaint. And you may say, well, gee, I'm going to pick one of my 4 defense mechanisms and say that, we're not. So what this does is this then begins the process of the lawsuits. Some documents will be filed in typically U.S. District Court, and then you begin this process of discovery. And this is what costs the money. This part doesn't cost too much money. It's just the cost to your lawyer. But now you've got depositions, you've got expert witnesses, and this is what can go on. This discovery process can go on for years and years and years. So again, you have 20 days to answer a complaint, so the process seems like it's moving pretty quickly at the outset, but the discovery process can drag on and on and on. A recent development is this thing called a claim construction, the Markman hearing. And what happened is that because some of the trials were taking so long and because some of the language of technology was so convoluted, there was there's a series of pretrial motions, and at some point there is a claim construction Markman hearing in which the judge finally says, okay, I've heard enough. I've learned enough. This is what the facts of the matter are, and I'll comment about a little bit more on the Markman hearing in the next slide. But presuming that the Markman hearing is definitive, that there is a foundation for a trial, the trial proceeds, and then depending on what the judgment is, the defendant may appeal or the plaintiff may appeal, and of course then you move on to the appeals court. So again, what I wanted to say was that the basic process, essentially the front end is actually very, very short and quick, but it's really the middle, the muddy middle, if you will, is the discovery process, and of course the trial and appeals can go on for years. So while the first part can take, let's just say, 2 months, this can take, 10 years. So essentially what happened is in 1996 there was this idea that the technology of patents was getting extraordinarily complicated, and so and it was really hard for the jury to understand the patent claims. So basically what happened is it used to be the jury that would establish the precedent, but now the judge is going to delineate the scope and definition of the patent claims. So what happens is, in the hearings, the plaintiff and the defendant do what we call teach the class. Basically, the judge hears arguments about what the claims are and what the technology is, and the judge will reach a decision on exactly what the claims are. Now that, once people understand what the clarification of the claims are, because I think we know, if you've looked at patents, you can understand that the claims can be very vague and broad, but essentially what will happen, the terms are intentionally used that are having multiple interpretations, but the judge is going to settle what the claim means in the context of the lawsuit. So this whole idea of the hearing was to establish what the claims are, and it really does, it promoted settlements prior to the jury, because once the claims were laid out in black and white in the context of the particular lawsuit, people were like, okay, we're clearly not going to win on this one, so it was simply more efficient. The judge rules on matters of law, what the patent language was, and the jury will rule on the matter of fact, the observed actions. That is to say, was this intentional? Was it inadvertent? And of course, you'd have damages associated with that. So basically, many, many cases now are settled at the Markman hearing when in fact the claims are made vivid in the context of the particular case of interest. Now, where do you do this? Where do you sue? Well, of course, patents in particular are a federal question, therefore it involves federal court. And some of the games are in trying to get a case moved from, let's say we're in the Sixth Circuit of Ohio. People may think that the Sixth Circuit of Ohio is not favorable to certain types of patents, so they may try to get the case moved to, say, Wyoming or any other different district. So there's some games associated with where to litigate, but no question that this is a federal question, and therefore it involves federal court. And of course, that would mean that the federal court is a U.S. district court. You can demand a jury trial because patents in particular and intellectual property, except for trade secrets, are federal questions, and the U.S. is a party because it's the Constitution. There is no minimum monetary requirement. So basically what will happen is that you go to court and there's a trial, and then you appeal it, as I mentioned earlier, and the judge panel, a court of appeals does not involve a jury, but the court of appeals is a judge panel. They can affirm the decision, reverse, vacate, or send it back. Okay, so there's a lot of different procedures associated with the court of appeals, and on rare occasions, actually the case moves on up to Supreme Court. Now, on the case of trade secrets, these would be contract law, and contract law would be settled at state court level. As I said, trade secrets do not usually go to federal court because it's a contract law. And sometimes these trade secrets might be difficult to prosecute because of the variance in laws in each state. The idea is that we have trade secrets versus trade secret law. It's one thing to have a trade secret. Trade secrets are kind of easy, actually, I think, as we've discussed before. The only thing you need to do is you don't need to file anything. All you need to do is within the company say, this is a trade secret, and then what you want to do is bind your employees to holding what they learned secret. Now, trade secret law, because something becomes more like contract law, and of course with contract law, things tend to be circumstantial and, of course, somewhat slow. So trade secrets usually involve employees that have left, and, of course, you certainly want to encourage employees to sign employment agreements, so you have the right to sue if the agreement is breached. So that's usually where the trade secret issues show up, is when an employee leaves or moves to a competitor, or something happens where the owner of the trade secret believes that the secret has been compromised. Litigation. Costs are hard to believe to the average person. You could be anywhere from 3 to 10 million, with another 2 million for appeals. And of course, many are solved for less, but this is really a multi-year process. And sometimes it can take up to 6 to 10 years. What's interesting about a lot of these court cases is the plaintiff loses 75% of the time against an infringer. So be very, very careful. If you feel you've been infringed, be very careful about suing, because more than likely you will not prevail in court. And when you sue, it puts your IP in play. So the patent can be ruled invalid, unenforceable, or simply not infringed. And again, antitrust and anti-fair competition can be raised by defendants, and that can erode your competitive position as well. So be confident of a good faith basis to the suit. Nothing beats being genuine. You want to avoid the frivolous types of activities. So what are the goals in a case? Again, as I alluded to earlier, you really have to have some objectives. Do you want market exclusivity? Do you really want to keep everybody out? Or do you want to use this as an opportunity for income? Many people are unaware that most companies will cross-license. Even if they're bitter competitors, they'll cross-license IP. And of course, it's compensation for losses. You might get a reasonable royalty. On occasion, there's punitive damages. And this is a case probably where people are thinking about exclusivity. But again, there is objective goals and there's subjective ones. What you might want to do is be promoting and protecting your licensing program. Or you want, subjectively, you want to be known as somebody that is going to defend your IP. So you want people to be cautious about infringing in your domain. So again, this is one of these barriers to market where what you're trying to do is to keep people out of your field. Here's a typical case. One you can look this up in Justia. This is this online source for all these federal cases, and here's one from Invacare Corporation that ran for about 6 years. I would encourage you to get on this website and do a couple searches. It's really fascinating. Of course, you can certainly spend a lot of time digging through these, but it's very educational to start reading the documents associated with specific lawsuits. It's better than reading a book. Read the real thing, and then you'll have questions to ask of yourself or of your instructor when you're actually discuss these things in class. One of the things we have to do is, litigation is bound to be present when we have anything of value, and so what you have to do is account for litigation uncertainty, and this is like any other long-term business liability. Basically what you want to do is you want to be sure that your balance sheet reflects a lawsuit contingency, and again, it's an estimated liability and reserve in case you lose a judgment. And what that looks like, of course, is that you've got assets in your balance sheet and you've got liabilities. So you're going to have You could have in here long-term liabilities. You could add another line in here, toss one in here, something related to lawsuits. So typical balance sheet is going to have, again, assets plus liabilities is equal to, assets is equal to liabilities plus owner's equity. That's these two down here. And so, of course, the, again, liabilities and owner equity is going to equal assets, and what you want to do is have your liabilities down here to include potential cost of litigation. So in summary, I hope what you're walking away with is the sense that IP management is highly multidisciplinary. It is, of course, intellectual property in whatever form you choose, is central to investors recovering their investments, particularly with respect to high technology projects. And please know you need a portfolio. The portfolio requirements will change over time. Consider being on the offense as your business grows. Be aggressive. Protect your territory. Because remember, if you create value, others will eagerly follow. And bulletproof claims in your intellectual property are the key to avoiding problems. So essentially, Lecture 2, Valuation Litigation, we highlighted a few aspects of intellectual property valuation. We saw that it can be highly subjective, and the thing to do is to work with the third party and double-check your numbers and double-check your approach. And again, like with everything, if you have something of interest, something of value, just expect litigation. It's just part of the game. So don't take it personally. It just means that people love you and that they pay attention to what you're doing. So what we've done in this session 6, we've done two things. We've made a basic introduction to the strategic nature of intellectual property, talked about some of the portfolio basics, hinted at the very flexible way in which IP can be evaluated, and those valuations have to be aligned with the type of IP. This is a case where you bring in a third party, not only for valuation, but when it comes time to litigation. All of these components form basically the strategic foundation in intellectual property for medical device design and innovation.